I want both of you to stand by because we're going to go to Brian Buckmire, our own Law&Crime network. He has been outside the courthouse while Jesse has been inside the courthouse, Jesse Whipper. But he's going to give us the feeling, the rumors, and what's happening and what he hears from outside the courthouse. Brian, good morning. Good afternoon.
Good afternoon, Linda. How you doing? So, Linda, as we've heard today, we got our first
Brian,
note, and we
speak
believe
up.
that might stem from some Yeah, Linda, can you hear me? Yeah. So we got our first note from the jury. Oh no.
I'm sorry. Say it again.
Hello, can you guys hear me? Linda is saying you cannot hear me. Hey, Linda.
I can hear you now, Brian. Okay,
Linda, so I want to.
Now you've got me really waiting. I'm
there
so
excited.
You go. What is happening outside the Weinstein courthouse? I know we shouldn't be playing this like this is the Roman Colosseum and the lions are coming out to attack the Christians, but it is interesting to hear the scuttlebutt. What's happening?
Yeah, so it is very interesting. Just moments before Gloria Allred came out, we found out that there was a note that was passed up from the jurors. Now, we believe that stems from some confusion as to the jury charges. Again, he's being charged with sexual predator as well as sex in the first degree or criminal sexual act in the first degree. Now, the judge told the jurors, hey, if you don't consider the first, you can go to the second, and then some vice versa has to not be able to consider. So the jurors came back and asked for a lot. They asked for definition of the charges and to understand what order, if any, they should be considering these charges.
So Brian, let me ask you this: did he give a verdict sheet that had that just followed the indictment, or did he give an order, a verdict sheet that's charged with the two counts that are the actual, I won't say victims, but the actual indicted victims in this case versus the Molyneux?
Yeah, so the charges are only applied to Mimi Haley and Jessica Mann. He gave a Molyneux instruction to inform that the Molyneux witnesses, those for the prior uncharged bad acts, should only be considered for forcible compulsion or lack of consent. So there is no facts or charges as it applies to the Molyneux witnesses, only specifically to that of Mimi Haley and Jessica Mann.
So does it appear that they're asking for a clarification on the forcible compulsion? Does that appear that they're confused about how they use the Molyneux then?
No, it seems they're asking questions of all of the charges, including predatory sexual assault, which is a Class A felony in New York State, punishable by up to a life in jail. And so that, I think, for the defense might be somewhat worrisome. I know they had a sidebar, Jesse was letting us know, where both the defense attorneys were shaking their heads as to how the definitions or the jury note might have been addressed. So it appears that they're asking questions not only of the lower or lesser included charges, but also still the top charge.
Do you know, Brian, if the judge is going to, in New York, mark the jury note as a court exhibit and have it available immediately to the public? And do you know who the foreperson on the jury is? Are you hearing from Jesse inside that courtroom?
So as to the foreperson, we don't know that as yet. What we're being told, actually, from the clerk in the court is that we will get the verdict sheet after the verdict has been given in. Obviously, a lot of us are looking to see what it looks like, how that breakdown is, and how the jury is seeing they're supposed to consider the charges. We're going to try our best to get it to you as quickly as possible, but from my understanding, not till the verdict is given.
And Brian, I know Jesse has been sending us notes from the courtroom, and he'll talk about it directly, but there seemed to be some kerfuffle about a juror number 11 reading a book. Do you have any more information just for us so we can get ready for Jesse about what that's about?
Yeah, so juror number 11, one of the 12 that would have been seated to contemplate or hear the charges after the case has been decided, they were actually seen reading a book. Now, both sides seem to agree. The book was about abuse, but the prosecution said it was about child abuse. Now, as often occurs, they brought the juror in by themselves and asked the juror a few questions. Now, you'll hear more from Jesse because he was in the room, but from my understanding, they asked the juror what they were reading and if at all, it applied to the case in hand. Now, the jurors said that they were not reading anything, even though the prosecution said they believed it was a child abuse case and not that of an elderly or an older man abusing younger people, so not really on point here. But the jurors said didn't read anything, didn't retain anything, and the prosecution argued that wouldn't be a violation anyway. So the judge kind of just said, let's keep it moving and continue the deliberation. So
we just heard a press conference, and I know you were there, from Gloria Allred, who represents two of, she says, the Harvey Weinstein victims. We have to say alleged at this time because he has not been convicted. But what is this scuttlebutt around the courthouse about Donna Rotuno's op-ed piece in Newsweek where she specifically addressed the jurors?
Yeah, so Linda, it's great that you actually brought this because I saw your email about this with Law&Crime about it, and I had to go to the op-ed. And in that op-ed, she's imploring, and she uses that word, imploring the jurors to come to the correct decision based on the evidence. Now, is that a direct communication between a defense attorney and the jurors to find him not guilty? Well, the judge decided that wasn't enough, but told all the attorneys, especially Donna Rotuno, not to speak to any of the media, make any op-eds until a verdict had been given, because they don't want anything to tamper or influence this jury.
So I know that Arthur Ardala, one of the defense attorneys who is a great New York trial attorney, has a lot of not guilties for defendants. So if you're looking to hire somebody, not that we are or I am, but in his law firm, he has a judge who's retired from the New York Supreme Court, Judge Barry Kamens. Do you think that that would have been run through him to see whether ethically he thought there was an issue, or whether or not, Donna Rotuno was like a ballerina dancing on that line and not falling over it?
I would hope so, because one of the allegations that the prosecution made when they said that Donna's op-ed had not only violated the court's order, but it also violated the ABA, or our ethical rules that all lawyers, not just in New York, but around the country have. They thought that this was a violation of the ABA rules. And so I would hope that that would be run by someone before she committed to an op-ed. Otherwise, not only would this case pose a problem for her, but maybe even her own license. Now, I personally don't think it rose to that level, but again, it's something you want to kind of stay away from.
Yeah, I don't either, Brian. I think that if she had posted it on her website, her closing, a transcript, and said, this is what I implore the jurors to do, that's certainly, it's akin to that. But having said that, what is the difference then? A lot of people have commented, and also Rotuno made an argument in her closing that Gloria Allred had been in the courtroom, and that these victims were, why did they have an attorney in the courtroom? And Ms. Allred, as you know, who virulently represents her victims, she is just on point with her victims. She's giving pressers a lot of times outside the courthouse. What's the difference between her giving a presser for the client she represents and Donna Rotuno giving an op-ed for Harvey Weinstein, who she represents?
Okay, so while both defense attorneys, Donna Rotuno is currently representing a defendant in criminal court pending charges with a juror that's already been impaneled. And so you don't want any information, especially when a juror is sequestered, to kind of permeate into that wall or through that veil where the juror is supposed to be only considering what's in court. Now, with Gloria Allred, she doesn't have the same requirements or obligations to that of the court, because she does not currently represent a defendant in criminal proceedings. So while they both carry the same hat of defense attorneys, their obligations are far and few between, because one is representing Harvey Weinstein, a criminal defendant in a matter, and the other is representing an alleged victim who has no criminal proceedings against her.
What are you hearing, Brian, from, the scuttlebutt of the reporters who may be getting secondhand information from their anchors who are seated inside? But what are you hearing from other reporters and the scuttlebutt around the courthouse as to whether or not they think this is going to be a guilty or not guilty verdict? This is the ultimate question of tea leaves I'm going to ask you.
So you know this better than anyone else, Linda. I definitely want to talk to the court officers. Now, as a public defender here in Brooklyn, actually some of the officers here, staffed, actually work in Brooklyn. So I want to talk to some of the court officers, actually, because they often get the best reviews of what's going on. In terms of the scuttlebug out here, a lot of people are on the fence. I mean, when I was there last week in your very own, the seat that you're in now, I think Ann Bremner said it best, that a lot of people think this is the right defendant or criminal, but maybe the wrong victims or wrong complainants, because it is very difficult for some people to get over that hurdle, even though Dr. Ziv said, hey, victims or alleged victims still contact their assailants afterwards. I think that's a bit of a struggle for some people to kind of overcome. So some people are literally on the fence as to where this could go. I don't know. I wouldn't bet money either way.
Yeah, it comes down, I know Gloria Allred, when she talks a lot about Dr. Ziv, and so did the prosecutor in her summation. Now, one of the issues that was addressed on cross-examination was the database that Dr. Ziv had, or how did she come to these conclusions? And I think, we all know women who have not reported sex crimes. By the same token, that office sat with 17,000 rape kits sitting in their office non-tested. How many of those victims contacted their rapists? I mean, didn't it seem like they dropped the ball a little bit with Dr. Ziv, relying on the 400 emails maybe with Jessica Mann to say he's not guilty?
I'm not sure if they've dropped the ball, maybe a fumble, maybe. We'll see if they catch the ball. I think they might have fumbled the ball to some degree, but the ball hasn't hit the ground yet. Now, whether one of their other arguments will pick that ball up before it hits the ground, thus stopping the play if we're going to continue with the football analogy, we'll see where that goes. I think there were some missteps with Dr. Ziv, maybe having her testify after the Molina witnesses and the alleged victims to be able to have a greater connection between their testimony and her findings. Maybe she spoke to one of them, but of course we know here in New York that if she had spoken to any of the alleged victims or Molina witnesses, that would have been discoverable material, and any one of these lawyers would have decimated through cross-examination even the most smallest sliver of inconsistencies. So I think they're kind of playing it close to the vest there.
So, Brian, thank you so much for being our eyes and ears to all the, let me say, maybe gossip, but informed gossip that is going on outside that courtroom right now. Hopefully you'll stay there, continue listening. But right now, we have to take one of those little tiny breaks that pays the bills, and we'll be right back.